Before we even hear the first word in this courtroom, understand what's really at stake here, not just custody schedules or paperwork, but the future rhythm of a 2-year-old child's life. This is a Texas family court, and today's hearing is a final trial that will decide how two parents, both claiming to act in their son's best interest, are legally bound to co-parent going forward. On one side, a mother who says she has been the primary caregiver since birth, focused on safety and structure. On the other, a father pushing for joint managing conservatorship, standard possession, and clearer enforcement of his rights. What makes this case compelling isn't screaming matches or explosive outbursts, it's the quiet tension, missed exchanges, missing medical information, disagreements over birthdays, insurance cards, and who controls what decisions. These are the kinds of details that don't sound dramatic until you realize courts live and die by details. Every delay, every omission, every unanswered message matters here. As you watch, pay attention to how the judge repeatedly pulls the case back to scope, relevance, and the law itself. This isn't about who feels wronged, it's about what can be proven, what was pled, and what serves the child. And trust me, the birthday ruling alone is going to spark opinions. So buckle in, because this case is a masterclass in how family court really works.
So we're set today in a final trial in a suit affecting the parent-child relationship.
Well, my name is Dorothy Horton, and I am my son's primary caregiver, and I have been since birth. The only reason I'm here today is not to halt visitation, it's just to give safety precautions and parameters. That concludes my opening statement.
Thank you, ma'am. Attorney Mitchell, you may call your client.
Mr. Craig, please tell the court your full name.
Michael Eric Craig.
And Mr. Craig, you saw the summary of request relief that we tendered to the court, correct?
From the email earlier?
Yes.
Yes.
Okay. And do you believe that what you're requesting is in your son's best interest?
Yes, ma'am.
You're still asking that the two of you remain as joint managing conservators of your son?
Yes.
Okay. And you're asking that you have a standard possession schedule with your son, correct?
Yes.
Okay. And right now the two of you are exchanging your son at the QT in Duncanville?
Yes, ma'am.
Tell the court how that's been going.
Well, I physically can't be there by 6 o'clock to meet to the demands of the paperwork, so I have a competent adult doing it. It's getting where it's hit and miss, where I don't get informed of information when we're running late. 5-10 minutes before pickup, I'm being notified my son is being sick. It's average that the average is about every 2 times that I go get him, the third time she may be on time. And
Okay,
it can be
and so-
anywhere between 1 minute to 30 minutes, depending on. And only one time have I ever received a notification that she was running.
This moment right here is more important than it might sound at first. When Mr. Craig explains the repeated late exchanges, sometimes up to 30 minutes, and admits he doesn't make up the time when he returns the child, he's doing something strategic. He's showing the court he's not retaliating. Judges notice that. Family courts are extremely sensitive to tit-for-tat behavior, especially when children are involved. What he's asking for isn't punishment, it's structure. He wants enforceable provisions so that if one parent is late, the other doesn't just lose time with their child. That's a key distinction. Courts prefer predictability over blame. The judge's questions here are designed to see whether this is about control or consistency. So here's the question for you watching. If exchanges are routinely late, should time automatically be made up? Or does flexibility matter more than strict enforcement? Drop your take in the comments, because judges wrestle with this exact balance every single day.
That she was running late.
Okay. And on the times that she's late by more than 15 minutes, do you keep your son an extra 15 minutes over the time that you're supposed to return him?
No, ma'am.
Okay. Would you ask the court to put those provisions in place so that you can have some provisions when Miss Hortley dropping off your son or picking up your son that you can get your time?
Yes.
Okay. Now, you're also asking for electronic communications, is that correct?
As far as like
So that
the well-being of
so that you have telephone communications with your son on Tuesdays and Thursdays of each week from 7:30 to 7:45.
yes, I would like that if I
Okay.
can.
Okay. And right now you're unable to exercise your Thursday periods of possession due to the distance that you all live from each other, correct?
Yeah, I apologize. You'll have to excuse me 1 second. Now say that again. Sorry, I'm in my jobs break room.
Right. So, Mr. Craig, you're asking for these electronic visits, this telephone communications on Tuesdays and Thursdays of each week in lieu of your Thursday possession period because you're unable to exercise your Thursday possession periods, correct?
Correct.
Okay. And that's just due to the distance that you all live from each other.
Correct.
Okay. And right now, how do the two of you communicate with one another?
Court ordered to use app close.
Okay. And has Miss Horton been putting all of the child's information in app close?
No.
Do you have information with regard to your son's doctors and dentists?
No. I don't even have social security number, birth certificate. Even when the opportunity just recently with my new job came up that I could get insurance.
Okay. Are you asking the court to order that Ms. Horton turn over that information to you on or before January 9th, 2026?
Yes.
This section exposes a huge co-parenting red flag, access to information. Mr. Craig testifies that he doesn't have his child's social security number, birth certificate, or even insurance details, despite being ordered to communicate through a co-parenting app. In family court, information equals participation. You cannot meaningfully parent if you do know who your child's doctor is or whether you can add them to insurance. The judge's focus here is practical, not emotional. She's not asking why the information wasn't shared, she's asking whether it needs to be shared now. Courts assume both parents should be able to act in emergencies. And when one parent controls access to information, even unintentionally, judges tend to correct that quickly. Ask yourself this: is withholding documents about protection or about power? The law leans heavily toward transparency when both parents retain rights.
Okay. And you're currently working at the same job that you were working at when we had our temporary orders hearing, correct?
Yes, ma'am.
Okay. And you're still making the same pay?
Yes, ma'am.
Okay. Are you asking the court to continue your child support at guideline child support, which you're currently paying?
Yes, ma'am.
Okay. And right now, Ms. Horton has health insurance for your son, correct?
I'm going to say yes. That's what she said in the court.
Okay. Are you asking that you have the opportunity to add your son to your health insurance?
I declined the insurance because I didn't know and it was too pricey at the time.
Okay. And so if Ms. Hort continues to carry your son on her health insurance, are you asking the court for you to reimburse her for the cost of the amount that she has to pay for him for his medical and dental insurance?
Yes.
Okay. And you believe that's in your son's best interest?
Yes.
Okay. Now, when we had our temporary orders hearing, Judge Lee ordered that you were to have some holidays and you were to celebrate your son's birthday, correct? This year.
Yeah.
Okay. Are you asking the court when is your son's birthday?
The 23rd
Of what month?
of February.
Okay. Are you asking the court to order that you have possession of your son on February 23rd for his birthday, since you have not had the opportunity to celebrate his birthday with him?
Yes.
Do you believe that's in your son's best interest?
Yes.
Okay. Now, all of the makeup time that Judge Lee awarded, you've already been given all of that makeup time back, correct?
Correct.
Okay. And moving forward, you're just asking for the temporary orders for you all to continue with the standard possession schedule.
Yes.
Okay. And but the only exception is for February 2026 for his birthday, that you have possession of him on that day.
Yes.
Okay. I'll pass this witness.
All right. Ms. Horton, this is now your opportunity to ask questions of Mr. Craig.
So as our son matures, how many days do you think you will be able to drop your son off or pick him up from school?
When it comes to that,
Yes.
if I don't have a competent adult, then I will figure it out to make sure.
Has your partner been doing every drop off since September 5th? Every
Objection
pickup?
relevance. Objection relevance.
Okay, ma'am, what's the relevance?
Big. I will have to say it's part of my testimony later as far as the temporary orders, competent adult being put in the orders when I didn't agree to that and I didn't have a copy of the temporary orders prior to that hearing.
Okay, so I think I can make this easier for you.
Okay.
By law, as required by the Texas Family Code, a parent can designate a competent adult to do exchanges for them
This is where the
of
judge
the
steps in and
child.
resets the room.
So you
When
both are
relevance
allowed to do
objections
that,
start flying, it's a sign
as well
emotions are
as
beginning to
birthdays,
overtake
because
legal
they
boundaries.
already mentioned
The
something
judge's
about birthdays.
explanation of the
So built
Texas Family
into
Code
the
is
law,
critical. Parents are
it
legally allowed to
automatically has
designate competent adults for exchanges, and birthday possession is already built into the statute. This isn't opinion, it's black-letter law. By clarifying this, the judge removes ambiguity and shuts down arguments rooted in misunderstanding rather than misconduct. It's also a reminder that family court isn't about relitigating feelings from past conflicts. It's about enforcing standardized rules designed to minimize chaos for the child. This is a teaching moment. The judge isn't scolding, she's guiding. And when judges educate like this, it usually means they're trying to prevent future enforcement hearings.
Automatically has requirements for possession and access during the holidays and a child's birthday. So both of those things he is entitled to according to the law.
Okay.
Okay, so you can go on and ask your next question. I'm going to sustain her objection about the relevance to
Okay.
adult.
Have you been paying guideline support on a consistent monthly basis?
Yes.
Have you been paying medical support on a consistent monthly basis?
No.
Do you think you've been flexible in our co-parenting arrangement?
Yes.
That's all the questions I have, Your Honor.
Okay, thank you. All right,
You're
Attorney Mitchell, do you have any other questions?
I have no further questions of this witness, Judge.
Okay, you may call your next witness.
I'll call Miss Dorothy Horton.
Okay.
Miss Horton, go ahead and tell the court your full name again.
Dorothy Horton.
Okay. And Miss Horton, have you been flexible in the standard possession schedule that's been given?
Yes.
Isn't it true that you've told Mr. Craig that you're not going to exchange the child and you don't care about the court's orders?
No, I didn't say that.
Ms. Horton, have you provided Mr. Craig with the child's health insurance information?
No.
Ms. Horton, have you provided Mr. Craig with the child's pediatrician or dentist information?
Yes, he has the pediatrician information.
Okay. But you've not provided him with a copy of the health insurance card?
No, not a copy of the health insurance. That's correct.
Okay. Isn't it true that Judge Lee told you that you had to provide a copy of the health insurance card to Mr. Craig?
Yes, that's correct.
Okay, but you still haven't done that, correct?
Yes, that's correct.
Okay. I'll pass this witness, Judge.
Okay, any other witnesses, Attorney Mitchell?
No further witnesses, Judge. I rest.
Okay. Ms. Horton, this is now your opportunity to call any witnesses that you may like. You may call Mr. Craig, and you also may call yourself as a witness or as your only witness. It's up to you.
Okay. Well, I would, during my testimony, like to call me as my only witness
Okay.
available. Okay. So, as a witness to that, me and Michael have had issues ranging from personal to co-parenting. I will not deny that. I will not deny that I did halt visitation because there was a myriad of problems going on, including stating that I was trying to control him, not willing to come up with a parenting plan on our own, an unwillingness to pay guideline support in lieu of any order. Anything I said to him resulted in us getting into it. It got so bad that I did restrict him to email. February 2025, a week before he filed this case in court. I would like to also state that Michael put himself on child support, which is no problem with that. It would give me guideline support. But when they weren't moving timely enough, Michael went ahead and filed this case. I also would like to state that in our first March 21st hearing, I might get the date wrong, but it was our March 2025 hearing, that Michael, he has 2 DUIs. He admitted to drinking on the stand. He has not made any voluntary effort to be tested.
Objection relevant.
Things shift dramatically once Miss Horton takes the stand. She openly admits to halting visitation in the past and restricting communication to email. While her frustration may be understandable, courts are wary of self-help remedies when a parent takes enforcement into their own hands instead of seeking court intervention. Notice how quickly objections come in when past issues like DUIs are mentioned, not because those issues don't matter in life, but because they weren't properly pled or supported with evidence in this proceeding. Family court is procedural. If it's not within scope, it doesn't exist for today's decision. Here's the reality. Judges don't decide cases based on who sounds more justified, they decide based on what fits legally in front of them. That distinction is painful for many parents and decisive in rulings.
Objection relevance.
Sustain. Go ahead.
Okay.
But you can't go ahead with what you're saying, the
Yes.
last part of what you're saying, but keep going with your testimony.
Okay. And not having, well, me as a mother, not having those parameters in place has been very taxing. Our arrangement as far as custody, it's been at least 4 parenting plans since he was born, our son was born. The first parenting plan was me as
Objection
the lead.
relevant.
Sustain.
Okay. So we had 4 plans throughout our son's life. So a standard
Objection
possession.
relevance.
Okay. The reason you keep getting that objection
Yes.
is because it goes outside of the scope
Oh, okay.
that you all are talking about.
Okay.
So, or what you all have discussed in terms of the case. So
Okay.
I'll tell you this. You've heard what he said he wanted, right?
Mhm. So
So
go to that.
tell me what it is that you,
Got it.
or what you don't want him to have.
Okay. So I would like sole managing conservatorship.
Objection outside of the scope of her pleadings.
Sustain. So that's going to be outside the scope because you never requested sole managing before today.
Oh, okay. I would like joint managing conservatorship with exclusive rights to major decision making.
Objection that's outside of the scope of her pleadings.
Sustain. So you joint managing conservator.
Mm-hmm.
Okay. Let me do this. This will probably be easier for you. He requested joint managing conservators. You're cool with that, right?
Yes, as long as I get major decision making.
Okay, so let me just go down the list of what it is and you tell me.
Okay.
For you to be the person who designates the primary residence of the child in Dallas or contiguous counties, you're okay with that?
Yes.
Okay. For you to also receive child support.
Yes.
For you to also enroll the child in school.
Yes.
Okay. And then all other rights and duties are independent after meaningful conversation. So the two of you have a meaningful conversation of what you all are talking about doing with those other rights and duties. And
Okay.
then you are flexible to make your own decisions. Are you okay with that?
I'm okay with that.
Okay. What about him having standard possession? Do you know what standard possession is?
Yes, ma'am, I do.
Okay. Are you okay with that?
No.
Okay. What type of visitation schedule are you asking for him to have?
Okay. I would like a modified schedule of every other weekend, not extended by in-service holidays. And I would like a reduced summer possession of 1 to 2 weeks.
And Judge, I'm going to object as that's again outside the scope of her pleadings.
Okay, sustain. I'm just going through with her and
Yes,
I'm
ma'am.
taking note of your objections. I'm just going
Yes.
through a summary with her.
I understand.
And he also testified that he's unable to do the Thursdays in person. So instead of those, he's asking for Tuesday and Thursday electronic communication. So they could be over the phone or it could be by Zoom at 7:30 and ending at 7:45. So for 15 minutes, those 2 days. Are you okay with that?
Yes, I'm fine with that.
Okay, you want to continue the exchanges at the QT?
No,
Okay. Where are you asking that the exchanges take place?
I'm actually, if I can ask for generic language, I've been stuck to under this,
You have to tell me what you mean by generic language.
like, non-custodial parent is to pick up child at a public area or public, I don't know how to put it, public
So
area by the home.
you don't want it designated.
Yes, that's correct. I'm sorry, Your Honor.
Okay, no problem, no problem. Okay, so let me explain to you the reason why the designation is so important.
Mhm.
So that's what makes it
The
enforceable.
exchange location discussion might seem minor, but it's actually about enforceability. Courts insist on specific locations because vague language creates conflict. A gas station, a police department, a fixed, verifiable place removes excuses and ambiguity. The judge explains this calmly, but make no mistake, she's preventing future litigation. If enforcement becomes necessary, specificity protects everyone involved. Even relocation doesn't eliminate the obligation unless the order is modified. This is a prime example of how judges think ahead. They're not just ruling for today, they're building guardrails for the next several years of this child's life.
Makes it enforceable. That's a very specific place. Now, if you say you didn't like QT and you all wanted to change it to maybe Duncanville Police Department, right? That's a very specific place. It keeps down confusion typically. And if something were to happen for enforceability purposes, we already know where you all are supposed to be exchanging, so there's no confusion. Does that make sense?
Yes. May I ask one thing?
Yes, go ahead.
Okay, so I do want to look at the possibility of moving. So that's the only thing that I'm kind of on the fence about, the specific um, address. Like, would I have to, if I move, would I have to still come to Duncanville
That's
to
a
drop?
great, that is a great question, and you will. No matter where you all agree to, um,
Mhm.
you will still have to come to that location. However, you do have because he's okay with it and you're okay with it, Dallas and contiguous counties. So that means you can live anywhere in Dallas County,
Okay.
and you can live in any county that touches Dallas.
Okay.
That's what that means. So even if you were to move, let's say you move to Ellis County, which is right there neighboring, you would still have to drive to the QT and do your exchanges. And the same goes for him if he were to move too.
Okay.
Okay. Let's see. A co-parenting app, you're okay with that?
Yes, we use app close. I'm fine with that.
Perfect. And I think it's a couple of more. I'll come back to that one last. I talked to you already about having the child on the child's birth, him having the child on the child's birthday. By law, he is entitled to 2 hours.
That's fine.
Okay. We cover child support. That is going
May
to insurance. Go ahead.
May I speak on
On the child
right
support,
now? Yes.
go ahead.
Okay. So he was never calculated a guideline support for his income. He said he made $1,200 to $15 in our March hearing. He's right now paying $213. He's a mechanic. I am asking the court to impute his income.
Okay, so let me tell you how that works. In order for me to entertain a specific request, you have to do it based on some evidence, right?
Oh, okay, got it.
So the only evidence that I have in front of me is this temporary order that he should be at guideline child support. You didn't provide any exhibits, or no discovery was performed or conducted for me to know that his child support should be anything different. Does that
Okay.
make
Yes, it makes sense.
okay? All right. Did that answer your question about the child support?
Yes.
Okay. The last one I wanted to talk to you about is the healthcare providers. You have to give him the he has the pediatrician's information now, right?
Yes.
Okay. You have to give him an insurance card. If he's going to be the person who carries the health insurance, he has to have an insurance card. 9 times out of 10, he's going to need it for his employer. So you have to provide that to him.
I have no problem providing a card. My main, in a previous hearing, my only issue was that he lets people know my address, my company name is on my insurance card, like it's on a lot of insurance card. And all of that I ask is that a redacted card is okay and that I don't have to give my social out because there's an issue there with
Yeah,
privacy information.
none of that happens. I wouldn't order someone to
Okay.
social security number. The only socials that I do require that are
Mhm.
are the children's social to have them,
Okay.
you know, but he definitely needs an insurance card. And I just would hate for you to have to come to court on an enforcement, right, behind something as small as an insurance card. Just give it to him.
I am.
Okay. All right. Is there anything else? I finished going over the summary of requested relief. Was there anything else you wanted me to know?
Just that my son is 2 years old. He's about to be 3, and I just want him to be safe. And I'm willing to let a lot of stuff go, but I just hope the court consider his age. Some of the things that have been said today when determining order.
Okay. All right. And he's getting ready to be 3, right?
Yes, Judge.
Yes.
Yeah, he has a birthday coming up.
Mhm,
Yes.
mhm.
So
Yes.
what I'm going to do, because it sounds like both of you are good parents. It sounds like you all care about your son very much. I'm not going to take that from either one of you. Good job, because if this is the most that I'm dealing with between the two of you, you all are doing good co-parenting. You really are. So I applaud both of you for working together. We just need you all to get a little bit closer in terms of co-parenting, okay? And I do believe you can get there, but you all have to show each other grace. So what I am going to do is I'm going to grant Mr. Craig's request in full.
This
Because
is the heart of the case. The judge praises both parents, then grants Mr. Craig's requested relief in full. That doesn't mean one parent won. It means the court found the requests reasonable, lawful, and largely uncontested within the pleadings. Crucially, the judge emphasizes modification rights. Family court orders are not life sentences. They evolve if circumstances materially change. That reassurance matters. It tells both parents, cooperate now, return later if needed. The tone here is intentional. This judge wants compliance, not resentment. And by validating both parents while enforcing structure, she sets expectations for mature co-parenting.
because as you know, you and I spoke, you were pretty much in agreement to everything. Now, this not to say for either of you, if something changes, something changes and it's considered material and substantial, you all are free to come to court to modify this order however you please, okay? So I don't want you all to think that, you know, this is just set in stone forever. If something major occurs, you have the option to come back to court at any time. So I'm going to grant his request in full, and I'm going to have this summary of requested relief emailed to you, Ms. Horton, as well as you, Attorney Mitchell, and Mr. Craig. You'll get a copy from your attorney. The Attorney Mitchell is going to draft it out and make it into the legal form, like the temporary orders. Ms. Horton, you'll get a copy of it. You'll have an opportunity to review it, sign it if you want to. You absolutely can choose not to sign it. The only person's signature that matters on there is mine, okay? So I don't want you all to think that you have to sign the order once she circulates it, but you at least are going to get an opportunity to review it. And then once I sign it, you all, that'll be good.
Thank you, Judge.
I got a couple of questions.
Sure, go ahead.
For as far as the first one is, as far as his birthday,
Yes.
for the day, since I'm getting for that day, his
Yeah.
birthday falls on a Monday of a
Mhm.
weekend that is actually my weekend of visitation. So would I just, instead of returning him that Sunday, do I just keep him that Sunday and return him 6 o'clock that Monday evening?
Okay, so let me tell you what the law says, and then I'll tell you what Judge Vonda would suggest. Okay, so You said it's the 23rd, so the 23rd is that Monday. So according to the law, the first, third, and fifth week, you have to give him back that Sunday at 6 p.m., okay? And then that Monday, which is his birthday, you will get him from 6 to 8. That's what the law says. Now, this is what Judge Vandervee would recommend, that the two of you co-parent through that and see what type of arrangement could you come up with. Mom, would you be willing to extend that having, maybe extend it to him spending the night until the morning of his birthday and then returning him?
Well, the reason why I asked that question was because Judge Jean had granted me the full day with him on his birthday for this year.
For this year? Is it
Yes.
because, the first birthday?
Yes.
Correct.
Okay. Let me do this. Mom, what is your opposition to that?
It was not in the temporary orders, both original and revised, and I do not want to do that.
Okay, so let me see. I'm looking at the temporary order. This is the most recent one from September, right?
Yes.
Yes.
I think Judge Lee made an oral ruling on that part. And so we were just going by the fact that she said that he was supposed to have the child's birthday for 2026. And I don't think it was included in the temporary orders.
And I think I gotta scroll back. I tried to highlight it on my tablet here. He missed last year's birthday, right?
That is correct, Judge.
Okay.
This was actually my first year to have him for a holiday period. Or,
Right.
excuse me, 2025 was. Excuse me. My apologies. I forget we're in 26 now.
Yeah, barely. We just got here. So, Miss Horton,
Yes.
what objection would you have to Dad having your son for the day of his birthday, since he didn't get him last year for his birthday?
What objections would I have? It's not in the temporary order or permanent order. I have tried to work with Mr. Craig. Mr. Craig has not been trying to work with me, so I'd rather just stick to the order, Your Honor.
So that's the temporary order. You all are in front of me on a final.
Yes.
So I could still do
Mhm.
creative for the both of you. What I'm trying to do is give you all an opportunity to kind of work through it just right here while we're speaking. Because if I have to make the decision, I don't know if everybody is going to like it. So I'll ask like this, Ms. Horton, because he did not get him last year. Remember, this is his son too, okay?
Mhm.
Would you be willing to allow Dad to have your son on the whole day for his birthday? And when I say whole day, I don't mean like you don't get to see him at all.
Mhm.
Like if he could have him until 6 o'clock or maybe even 4 o'clock. He's not in school, right?
No.
No, Judge.
So if he were to have him till 4 o'clock and then you have him for until the rest of the time, because after that it's your time anyway. And this is just this year. We're not talking about 27 moving forward or anything like that. It'll default to what it is, but specifically for this year.
Your Honor, you can make your decision. To me, it's a day. My son needs to be taken care of every day of the week, so I'm not worried about a day. So go ahead and make your decision.
Okay, so this is what we're going to do. Dad is going to, let's extend the child's birthday. So instead of Dad turning over at 6 p.m. on that Sunday, Dad, you're going to keep the baby until it's little Michael. You're going to keep little Michael. You're going to keep him overnight. And then the next day at 3 o'clock, take him to Mom.
Okay.
I think that's fair. So the both of you can see him on his birthday, and that's just for 2026. Moving forward, it'll be what it normally is, 2 hours during the birthday, okay?
Yes.
But if you all decide to come to something different, y'all may want to throw a big joint birthday party at Chuck E. Cheese or something. And y'all decide to do something different, You're more than welcome to do something different. I will not have any quarrel with that, okay?
Yes, Judge.
Okay. Well, that's it. Do either of you have any other questions?
No.
Yes, ma'am. Can I have the court request Miss Horton send a copy of the actual portion she pays of the insurance for my child? Proof of her, not just hearsay?
That was on our requested relief, so it was
Oh, okay.
requested that she provide the benefit information so that we know how much he has to reimburse.
Oh, yes. Miss Horton, you're gonna do that, right?
Yes, I am.
Okay. See, we're not gonna have any problems. Okay. Well, if there's nothing further, you all are excused.
So let's break this down clearly. The court ordered joint managing conservatorship, upheld guideline child support, reinforced information sharing, clarified insurance obligations, and resolved the birthday dispute with a balanced, child-centered compromise. No punishment, no theatrics, just law applied as written. This case shows how family court prioritizes structure over emotion, evidence over accusation, and the child's stability above all else. Both parents walked out with rights and responsibilities. Now I want to hear from you. Did the judge get it right? Would you have ruled differently on the birthday or possession schedule? If you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.